Okay, let's get started. I'm Kimball Parker. I'm the CEO of 650. For those of you that are hearing about 650 for the first time, we're the technology subsidiary of the law firm Wilson Sonsini. And what we've done is we've taken their employment document library. So think like employee handbooks for all 50 states, employment agreements for all 50 states, and we've automated them like TurboTax. And we've done this because several clients of the firm have struggled to keep up with employment law as their workforce has distributed throughout the nation. And so we've automated all the documents that a company needs to hire, manage, and let go of employees in all 50 states. And that's what 650 does. So that's 650. So for today, we have a great webinar on this topic. And you're going to hear from some of the people who actually built our tools. So you're going to hear from Adrian Jack. Adrian went to Northwestern for law school. She graduated top of her class, worked for some of the biggest firms in the nation. We pulled Adrienne over. She built our employee handbook, 50 state employee handbook product. So there isn't really, I don't think anybody in the nation who knows more about what to put in your handbooks at what time, depending on what states you're in, than Adrienne. Next, we have Adam Wright. Adam attended the University of Michigan Law School, currently resides in New Mexico up in the mountains. We just got a tour of Adam's house, actually, great place. And Adam, after law school, clerked for 2 years on the federal court, and again, worked for some really important firms nationwide. Adam built our employment agreements module. So for all 50 states, so he automated offer letters, employment agreements. Some people call them PIAs, or proprietary invention assignment agreements, and independent contractor agreements, and all the documents you need to hire anybody in any state. And so today we're gonna talk about how to manage your employees when they work from wherever, and some of the legal how-tos for human resources. We also have on Marie Kulbeth. She's our resident legal expert about everything. Marie attended the Brigham Young University for law school, graduated top of her class, clerked on the federal circuit, on the Fifth Circuit. Marie? Fifth Circuit. Okay. Clerked on the federal circuit for the Fifth Circuit for after law school, and then was a law professor, and we poached Marie away. So you're going to hear from all three of these experts today. If you're interested in our products, you can go to 650.com/employment, and we can put that in the chat. But if you're interested in a demo, seeing the tools, seeing how they work, we'll give you a really no promo at 650.com/employment. So without any further ado, I'm going to turn the time over to Adrian.
Thanks, Kimball. Thank you for joining this webinar today. So to give you an overview of what we're going to talk about, first, we're going to talk about which state laws govern employment relationships and when that differs. Next, we'll talk about some of the legal considerations to think about in a dispersed workforce. And then finally, we'll end with managing the employment agreements for that dispersed workforce and considerations to think of and what to keep top of mind. So many of you may have seen in the news, but Airbnb announced kind of a radical remote working policy. So let's jump to the next slide and kind of unpack what Airbnb announced in their policy. Airbnb, the CEO, announced that employees can work from the home or the office. They can work anywhere. And some companies are doing this, but we'll see that Airbnb's policy is much more expansive and global than any other policy that we've seen so far. So this allows most employees to have flexibility. A small number of employees will still be required to go into the workplace for certain core roles, and those employees are pretty limited and have been notified. But a big announcement was that employees can move within their country and their compensation won't change. So employees have the flexibility to move anywhere within the US and to one of over 170 countries across the globe. And they can move to those other countries for up to 90 days. And Airbnb is working with different local governments and state governments to make sure they have the right visas and permits in place to allow employees to do this. So within each country, there's one pay tier, and that's for pay and for the equity that employees would receive. So it's really kind of uniform, making a uniform standard across these workplaces that we haven't seen kind of on this scale before. Though employees will be kind of have flexibility to work from anywhere, there are still certain expectations around meeting up in person once a quarter for most employees, and that's for up to a week at a time. But then for top tier executives, that might be more often. And Airbnb acknowledges, I think what most companies are acknowledging is that while dispersed and flexible work is fantastic and allows employees a lot of flexibility and brings a lot of employees like that as a job feature. However, there is something to be said about being in person and being able to build trust with in-person relationships. So Airbnb acknowledges that while Zoom is great for a lot of meetings, being in person still adds a lot of value and helps build trust and connect relationships in ways that Zoom can't. And so employees will still have those expectations to meet up in person for once a quarter. As well as Airbnb said they're continuing to work in a highly coordinated way. Even though they'll be across 50 states and 170 countries, they still anticipate having core working hours and having kind of a company-centric multi-year roadmap. And they have kind of 2 announcements of new product releases per year. And their whole company roadmap and company cycle kind of focuses around those, even for employees that might not be working on that particular product or feature. They still kind of plan around that to give the company kind of uniformity and central goals to work behind. So Airbnb is trying to solve for what questions? Why did they announce this policy? And they announced this policy for the reasons that many companies have these remote working policies. Let's jump to the next slide. They're asking 2 questions. And the first is, where is the world going? The world is going remote. The world is going flexible. We saw a couple decades ago that Silicon Valley started with tech companies having open floor plans and on-site perks and arcade games and food catering services. And that hit the time. That was very appealing for employees at the time. But now what is appealing to employees? This flexible remote workplace. And so companies are answering that desire for employees by offering this to them. And then the second question is, why are we doing this? What are we solving for? And you're solving for trying to attract and retain the best employees. Companies are realizing that the best employees aren't always those who are living within a drivable distance from their offices. The employees are scattered across the country and across the globe. And as we know, hiring is more difficult than ever. There's a shortage of employees, and the Great Resignation is making it difficult to find those employees and retain them. So having this flexibility to hire anywhere really opens the talent pool for companies and allows them to find the people regardless of where they're located. So that's kind of the background of this webinar. As we looked at this policy and we thought about, okay, how is Airbnb doing this? What are considerations they're thinking through as they're formulating this really expansive, robust policy that gives employees a lot of flexibility? But our first thought when we saw this policy is, this is a nightmare for companies. Having to do this sounds, as Maria, as our general counsel, can attest, this is a nightmare. This would be so tricky and difficult. And Airbnb might be in a different situation than many companies. They have over 5,000 employees just in the US. So they probably have resources that not a lot of companies have. And they probably have employees in a lot of places that most companies already don't. And so we'll look at it through the Airbnb lens, but also through the lens of other companies who might not have the resources of Airbnb or 5,000 US employees, of what considerations can they think through to allow employees to have flexible working arrangements.
Yeah, Adrian, nightmare is exactly how I think of it as general counsel. Because right now I already evaluate these requests, right? And we're a much smaller company than Airbnb. But, just 2 weeks from now, I have an employee who's moving to a new state where I haven't previously had employees. I have another employee who's just submitted a request to work remotely for 3 months from a different location than the employees currently working. So these are real things that are happening in companies of all sizes. And, as I evaluate these requests, there's a lot of things that I have to look at. And one of them, which does make, our organization different than Airbnb, one of those questions is, am I submitting myself to a new governing law that doesn't already govern me generally? but then also employment law specifically, right? Like, what laws are going to apply to this employee that might not currently apply, or that, might be different than the laws that applied when they signed their employment agreement. And, what should I be looking for when we make these decisions about whether to allow these moves or these temporary relocations? Because those can be different, right? A permanent move and a temporary relocation will have a different impact on your business. So we're going to talk a little bit about all of those things today. So I know some of the people on the call today are HR specialists, some are lawyers. I'm going to give a primer that might be helpful to both, a little bit about some legal issues regarding governing law. So as you're looking at, employees going to new states, the things that you need to think about are, which state's law will govern in different types of situations, because it's not just one answer for all situations. So sometimes you'll have specific statutes in a state that will determine whether that state's laws will apply. So for example, or that address a specific area of an employment law. So, employment discrimination laws are different from state to state. Non-compete rules and laws regarding whether they can be whether you can have one, what kind of notice you have to give if you're going to have one with one of your employees, and some other restrictions. Leave policies. So from an overall perspective of what's going into your employment handbook, which states do you have to address in your handbook for your leave policies? Will you have to treat the employee differently if they make this permanent or a longer term temporary move? And so it can be really statute specific. And one of the biggest practical tips that I can give you is to look to the state's definition of a covered worker, right? So when you're determining, okay, this employee who's currently in Texas wants to move to, Washington State, say, okay, as I'm evaluating, these differences, will this person be a covered worker in Washington or will they not? And if they are, then there's some other statutory implications that we'll talk about more in a minute. Another thing to think about is choice of law or conflicts of law. So you want to be able to make some decisions about what law will apply, because in some situations where it's unclear, if you've made a decision in your employment agreement with that employee, that could help clarify the situation, and a court hopefully would enforce the decision that you made in that employment agreement, as long as you had based it on appropriate principles. So, if you have an employee that is, moving to the state of California, you as a company are based in Ohio, the employee was previously living in Illinois, and you've got a pre-existing employment agreement that made Illinois the choice of law, and now they're moving. It's like, okay, what are the principles that I need to think about? So we'll talk about choice of law for a minute after this slide. And then we'll also talk about localization rules from the Department of Labor, which specifically govern unemployment tax and unemployment insurance, and then just your general rule of thumb. So the best answer is typically that the state in which the employee is physically working is the state whose law will apply. But again, that's a rule of thumb. If the employee is working in more than one state, that rule doesn't quite get you to an answer, right? So we'll talk about all of these in a little bit more depth now. So, and I did also want to just mention, you may also have some specific governing law that's coming from a city or county. I think that we all saw this to a whole new degree during the pandemic, when in addition to federal guidance on some issues and state guidance on other issues, we also had citywide guidance where some states had mask mandates and other states didn't. But then within that state, without a mask mandate, you might have some cities or counties that had one, and those would govern your employees and the things that you had to do in your work sites. So there's a lot of different situations where these laws can come into play. Business registration rules, your sales tax rules, leave requirements. Sometimes they are even city specific, and minimum wage laws. Those can all vary on even that very specific jurisdictional level. So an employee just telling you, I want to move to New York, doesn't quite get you there. You need to know that they're planning to actually move to New York City, or are they, planning to move to Westchester? Where are they going? So you need to know that level of information when these requests are being made. So we'll start by talking a little bit about governing law regarding the conflicts of law issues. So if we could advance to the next slide. Essentially, oh yeah, I did want to remind you again, rule of thumb, there's a conflict, where's the person working? That's the rule that we're going to apply. But now let's talk a little bit about some situations that might change that. So choice of law principles, and again, for some of you, this is a rehash, but for some people, it might be the first time you've heard some of these things. If there's a jurisdiction that has, one law that's going to govern your employees. So, in one jurisdiction, you're not allowed to have a non-compete, and in the other you are. The employees potentially covered by both jurisdictions because there's some level of contact, right? How do you make a decision about which law will govern? Essentially, the first thing is to invoke the laws of a state. You've got to come under the jurisdiction of that state. And so one of the parties in the situation has to be a resident of or have sufficient contacts with the state. So this comes up a lot. Some employees live and or work in what you could refer to as border towns. And so, you're near the state border, you're living in one state, you're working across the border in the other state, pandemic happens and you go remote, and now you're working in the state in which you live, not in the state in which your company has its headquarters or offices. So now you have this potential conflict, and you have really significant contacts in both states, right? So some states, for that temporary situation during the pandemic, some states put in place border rules specific to the pandemic that are now expiring. But we still have those employees that have moved to working remotely. So while before it might have been temporary, now that's a permanent move. And if that's a permanent move, you're going to be reverting to the rule of thumb, which is they're doing all of their work, in that state in which they live because they're working remotely from home now. Maybe they come into the office in the other state like once or twice a month. That's probably not going to be significant enough to overcome, the state in which they live being the choice of law state. But these are the principles you have to apply, right? You have to say well, are there contacts with both states? And if there are, then I have to look at those states' conflicts rules. And this is where it gets hard because each state has its own rules about how to decide conflicts of law issues, and they're not all the same. But as a general principle, they tried to treat it as a question of, where's the significant impact of this this employee's employment. And that's why where the employee physically works is the rule of thumb, right? Because underneath it all, where they're doing the work is typically where a situation will have its greatest impact. But there are some exceptions. And one exception is, if the state where the employment situation is happening doesn't have as strong as an interest as another state. So I'll give a recent example that happened between Massachusetts and New York, where there was a Massachusetts employee who brought a case alleging workplace discrimination and asserted claims under Massachusetts law. The employee had been working and living, working remotely from Massachusetts, but for a New York company, a New York City company. And at the end of the day, the court actually found that New York City was the most appropriate law to look at because the impact of this discrimination claim would be most felt in New York City, the impact of the allegations. And so that was a really interesting exception to what we would have considered the most likely outcome that occurred not during the pandemic, but pre-pandemic, but in a similar situation, right, where the employee had been working remotely. So while choice of law principles would typically say rule of thumb, where's the employee work, that doesn't always get you there, especially if the employee is working in multiple locations, like we'll be seeing in companies that implement policies like Airbnbs, where you could, maybe work somewhere remotely for up to 3 months even. In a lot of situations, that will be enough to trigger the employment laws of, the temporary state. So again, general principles, but then we might have some specific situations where we have to apply a different rule. And some of these will be clear because, again, it'll be statutorily determined, where a state will say if an employee is working, in New York for this many days during the year, then our, employment discrimination law applies to them. So sometimes it is that clear, and other times it's not. That's why you should think about choice of law principles when you decide which law to put into your employment agreements, because if there's a lack of clarity in the law, then the agreement itself, it's more likely that they'll enforce the jurisdiction that you've chosen. So there's your choice of law principles, a little cursory introduction to it for people. And now let's talk a little bit about the Department of Labor rule. So the Department of Labor rule is the one that applies. It's called localization of work. That's the name of their rule. And it's the one that will apply when you're deciding unemployment, insurance, and tax questions. And unlike choice of law, which can be really confusing, the localization rule is great because it's a series of 4 questions that you have to ask, and based on your answers to the questions, you get, an outcome. And it's uniform in the sense that every state has a localization of work rule that is based on the Department of Labor's. So essentially, the rules there so that you have principles for determining where to report wages for unemployment tax and unemployment insurance purposes. And you can just do one state for the employee instead of having to try and have unemployment insurance coverage, in multiple different states for the same employee. So it addresses the issue of if an employee works in either one or multiple states. So that's really helpful. So you don't have conflicting rules, at least in this one area. Again, generally, it's the state where the employee is performing the work, but I'll go through the questions now with you so that you can see how that might change if there's more than one state in play. So let's go to the next slide. And these are the 4 questions that you have to ask under the localization rule. And keep in mind, you have to ask them in order. So as soon as you get a yes, you have an answer when you apply these questions. So the first question you ask is the employee's service localized in one state? So if, the employee, that employee I mentioned from the other case, right? Massachusetts, doing their work in Massachusetts, being governed by a home office in New York. For localization for unemployment tax purposes, that person is purely doing work in Massachusetts. And so, yes, it's localized in one state. The state is Massachusetts. That's where the unemployment insurance tax goes. So there's your answer. But what if we'd said no? What if it's like, oh, this employee is working in multiple states. We don't have one clear winner here. That's when you say, okay, well, is the employee performing any services in the state where they have their base of operations? So that's a situation, say you have, this comes up really often with airlines. So say you have, a flight attendant who has a hub airport. They work out of, the Dallas airport. And so Dallas is their hub, but, then they go to every state, right? They can go anywhere. Since they're performing some services in Dallas, and Dallas is their base of operations, then you would say, okay, Texas is where you'd be paying the unemployment insurance tax. What if we still had a no, right? What if they didn't have a base of operations where they're performing work? Maybe they're purely remote, home base is an office in San Jose, California, but this person never actually goes to California. They're always somewhere else. That's when you get to question 3. And it's saying, well, do they perform any work where their business is controlled from? And in my hypothetical, I just said no. But if I'd said yes, then it would have been like, okay, that's the state. But if we've got a no here in question 3, then we still have to go to question 4. Okay, are they performing any services in the state where they live? So I've got that home base in San Jose, California. I'm currently living, in Miami, Florida. If I perform any services in Miami, I say yes. It's like, okay, great. Florida is the state for unemployment insurance taxes. If it's none of the above, this is a really fun situation that can occur. There's a little thing called election of coverage, where almost all of the state laws allow for the employer to elect a state. That can be done under those state rules or under the interstate reciprocal coverage arrangement. And essentially what that means is then you can elect coverage in any of the states where you have one of the following: a state in which some part of the individual's service is performed, the state in which the individual lives, or the state in which the employer maintains a place of business. So essentially you just said no to all of these questions. And so it's like, okay, well, we'll kind of just let you pick, right? One of the ones that has enough context. The employee lives there, they perform some services there, or you, the employer, are there. So that's how you handle it if you get to number 4 and you're still at no. So that's more rare, but it can happen, especially now in this changing work environment. So that's the Department of Labor localization rule. And again, that's specific to handling issues of unemployment insurance and unemployment taxes. And now though, we'll switch over and Adrian's going to talk a little bit more about wage withholding. I did see somebody in the chat had been asking specifically about wages. So I'll let Adrian handle that subject.
Yeah, it's unfortunately, each of the tests are different for different purposes. So while you may have one state as a governing law for the state where you need to submit unemployment insurance, it might be a different state where you need to withhold from an employee, withhold income taxes for an employee and submit those to the state. So 41 states in the District of Columbia have a personal income tax, which means there is a withholding requirement for employers to withhold that from an employee's wages and submit it to the state. And unfortunately, each state has a different requirement for when it triggers that requirement to withhold from an employee's wages. So Airbnb and their policy said that all employees need to submit a permanent address for payroll and tax purposes. And that's a great starting place. But unfortunately, you can't just say, oh, the employee has a permanent home in Massachusetts, but they're, living for a month in 12 different states of the year. So we only have to withhold in Massachusetts and submit it there. That's not the test. There is a different state requirement and it's governed by state law. So each state has a different trigger of when you have to withhold income taxes for that employee. 8 states have a time-based withholding requirement for employees. So that would be Arizona, Connecticut, Hawaii, and the other states listed here. And that means that in these states, if the employees are in the state working for more than a certain number of days, then you have to withhold their income taxes and submit it to that state. For example, Arizona's is 60 days, but some states like Connecticut are 15 days, and they're a lot smaller requirements. So if an employee is working there for 3 weeks, you are technically required to withhold their Connecticut income taxes and submit those to the state. 6 states have a wage or income threshold. So if an employee earns a certain amount of money while working in that state, then you have to withhold their wages and submit those to those states. And then you'll see here that Georgia and Maine have a combination of both an income and a time-based requirement for triggering that withholding of income taxes in those states. So for example, some states have a kind of a poverty threshold where if you earn more than the poverty level in that state, then you have to withhold and submit income taxes to that state. But others like Idaho, for example, if you earn more than $1,000 in that state, then you have to submit those contributions to the state of Idaho and withhold wages in that state. So this is complicated. Unlike the unemployment insurance where it's a localization test and you have one standard that's across all 50 states and you are only withholding unemployment insurance in one state, you could have situations where you have to withhold wages in multiple states. So if an employee is moving each month of the year, you might have to withhold in one state and then stop withholding there. And then if an employee moves to a new state, start withholding in that state, even though they might have a permanent address that's totally different from the states where they're remotely working. So this is difficult to track, and Airbnb indicated in their policy they want to create an open source solution to this problem, and they want to share that so other companies can facilitate remote working easier for employees. I know at 650, we're curious on what that looks like and how they could reduce this burden for employers to track where employees are working. I mean, if they're moving so frequently, you need to know where they are working and for how long they've been there. And then you need to track the time and the wages that they're earning in all of those different locations. And then 22 states and the District of Columbia don't have any withholding thresholds based on a time period or income or wages earned in that state. So technically, an employee working for any period of time or earning any number of wages in that state should be withholding income taxes from that employee and submitting those to the state tax department, tax or revenue agency. So this is hard. There are 8 states with some requirements, 6 states with others, and then a lot of states technically have a day one requirement where as soon as the employee lands there, you need to withhold and submit those to the state. So this is something that companies need to keep track of. And as we've thought through, okay, how can small companies do this? We haven't found any great solutions. It is complicated to track. And while companies like Airbnb, they might already have payroll and withholding set up in all of these states. And so though they have to kind of turn them on and off and say, okay, Marie's working in California now, so let's withhold there. Okay, now let's stop withholding there. And now let's withhold in Illinois. For many companies, they are not set up to withhold wages in those states. So they have to then start from square one to register with the Department of Revenue in that state, submit all the paperwork necessary to be registered as an employer there, and then be able to withhold there. So that's an onerous burden on companies that not a lot of companies have the resources to take on. Okay, let's actually ask a poll question about this. In how many states are you withholding wages for employees? So this might be how many states you have employees, or you might be withholding in more states based on employees temporarily living in other states. So we'll give you about 10 more seconds to answer this. I'm interested to see how many states and based on, the complexity of your workforce, how you are handling these issues. Okay, let's go ahead and close that poll. And so it looks like, and just to give you an idea, there are about 80 people that answered the poll question, 80 companies that answered the poll question. So the vast majority are in the 2 to 5 employee range, or they're withholding wages in 2 to 5 states. And that's kind of a more manageable situation where you can keep tabs on the state Department of Revenue in 2 to 5 states. But we do see a lot of companies in 6 to 10 states and more than 15, which is very complicated and often requires multiple people that are tracking where employees are working with the Department of Revenue, working with the payroll company to make sure that all of these pieces are working together. So very interesting. Thank you. Thank you for answering that poll question. Okay, we're next going to talk about so if you do have employees working in new states, what are some other legal considerations you need to think of? What do you need to do to set up that employee to work there and to do it legally compliant? So often the first step is registering to do business. Having a remote employee in a state often constitutes conducting or transacting business in that state. And almost every state has a statute that says if you are transacting or conducting business in our state, you need to register with the Secretary of State and get a certificate of authority or a statement of authority to do so. And this is often step one before you can register for withholding, to submit unemployment insurance, any of those. This is often the baseline step that you need to do before you can do those other steps. And this often means getting a foreign registered agent, so a registered agent in that state who can receive mail on behalf of the company, if there ever is one. Since this issue of remote working is relatively new, and as many of you have seen, the law and regulations are slow to keep up with how the modern workplace works. So we haven't seen many companies directly address this issue head on. Many of them have older statutes that say, if you're conducting business, you need to obtain a certificate of authority, but we haven't seen many states say only having a remote employee in the state constitutes transacting business. Colorado, in their Secretary of State frequently asked questions, said, does having a remote employee constitute transacting business? That was their question. And then their answer was, it depends. You need to look at the statute. We can't answer based on your facts and circumstances. So we haven't seen any clear answer, but the safest and most conservative approach would be to register to do business in a state if you plan to have a remote employee there. Okay, and then on the next slide, here are some other issues you need to think about when you're setting up an employee to remotely work in a new place. You need to report that new hire. Every state has a new hire reporting requirement of you need to submit that employee's information to different agencies to notify them that that employee is working in this state. And that's often to track child support withholding orders to make sure that those are being fulfilled if necessary. Also, you need to make sure there's workers' compensation coverage for employees that extends to that new state and make sure your policy includes that. As Marie mentioned, you need to analyze the localization test and determine where you need to register for unemployment and submit those contributions. And then also many states have different paid family and medical leave authorities, and you need to register with those to make sure you're submitting those contributions or participating in the required programs. And then here are some other considerations on this next slide to think about of when it comes to tax registration, you need to think of income tax, which we talked about how to withhold income taxes and what the wage standards are for that. But there are also sales and use tax in many states. And sales tax, there's often two standards to determine if there's nexus in a state. One is an economic test. If you have a certain number of sales or collect a certain amount of revenue in a state, sometimes you're required to withhold sales tax in that state. But the other test is if you have a physical presence, and having an employee in a state is a physical presence. So you would be then subject to sales tax in that state where you have a remote employee working. And that's often a big question when you're considering, can we support an employee working in a new state? Is, are we ready to be subject to sales tax in that state if we don't already have an economic nexus there? So that's a big question that companies need to think through as they're allowing employees to work in new locations. Let's move to the next slide. And then finally, there are a host of considerations. We could spend all of this time talking about all the considerations companies need to think about to be legally compliant to have employees in new locations. But here are just a few. Most states have at-will employment, but Montana does not. And so companies need to make sure that they're aware of that if they have employees who are locating there. Each state has a different minimum wage requirement, as well as what constitutes exempt versus non-exempt employees. And that means if you have employees in a new state, you need to make sure that you are paying overtime when it's required. So many companies think that, oh, we only have to pay overtime if an employee is working more than 40 hours a week. And that's true in some states, but that's not true in all states. We know a company that relocated to California and had employees working 10-hour days. They had them working 4 10-hour days. So they were working under or at 40 hours a week. But California has different standards for when to pay that overtime. And if you work more than 8 hours a day in California, companies need to pay overtime to those employees. So that was a big labor issue and potential lawsuit for companies that aren't being compliant with the overtime laws in that state. As well as you're tracking these different wage withholding requirements, each state has a different requirement regarding how frequently employees must be paid. Some states say employees have to be paid weekly. Others say every 2 weeks. Some say once a month, and some say there's no requirement. You can pay as frequently as you'd like. So when you're considering whether to have employees in a new state or allow employees to relocate, think about what are the pay frequency requirements in that state, and does our payroll system align with that, or could we get it to align with that to make sure that we're complying with that pay frequency law? There are employment notices and signage requirements in each state. Some states, most companies already have the labor law signs in place, but some states require you to have a written acknowledgement or provide a written notice directly to an employee about the wages that they might be paid or the sexual harassment policy in that state. And that's more than just posting a sign in the workplace, is you have to make sure employees receive that notice and in some cases acknowledge that they received it. There are also sexual harassment training requirements in certain states. COVID regulations differ by state. California is one of the most onerous and requires companies to have a written plan about COVID prevention, but other states might have different COVID laws and restrictions, and companies need to make sure that they can meet those compliance requirements. Insurance coverage is a big one for making sure your insurance coverage at your company can extend to employees in a new state, might be a big issue. And then, as I mentioned, the labor posters differ by state. So there are so many issues to think about. These are just some of them. So while Airbnb and their workforce and their resources might be able to facilitate a 50-state workplace, many companies, when they think of these issues, might not choose to do so. So these are the issues to think about as you're expanding your workplace. Okay, I'm going to turn the time over to Adam, who's going to talk about employment agreements and contracts and some of the legal issues to think about.
Thanks, Adrian. So I'd like to start off this section with a poll question here. And our question is, does your company use the same form of employment agreement for employees in multiple states? And your options are yes, no, or if your company doesn't use employment agreements, you can note that. We'll just give you maybe 10 seconds or so to answer that question. Okay, let's take a look at those results. All right, so we have a little over half of you that do use the same form of employment agreement for employees in multiple states. About 14% don't, and then 30% don't use employment agreements. for those companies that are using the same form of employment agreement in multiple states, we'll talk about some issues with that and some potential trouble that you may run into in trying to enforce those agreements. For the companies that don't, I'd be interested to know how you go about using different employment agreements for employees in different states. And then for the companies that don't use employment agreements, I think there are some probably some issues there with making sure that all of your company confidential information is protected and that you're adequately protecting your company. So let's move into the next slide here. So as we've talked about, there are really potentially massive benefits for companies that are moving to a remote workforce. The labor market really expands, your ability to attract top talent potentially increases, but there are a lot of complications, which we've talked about, and I'm sorry to report that those complications also extend to your employment agreements. And so when it comes to employment agreements, having employees in multiple states can be really tricky. There are significant differences, as we've talked about, between the states and employment law. And because of that, a company really shouldn't be using the same form employment agreement for employees in different states. So to be confident that all the provisions of your employment contracts are going to be enforceable, your agreement really should be state specific. And as Marie talked about, it typically should be specific to the state where the employee is located, although there are some exceptions to that. And so today I'm just going to highlight a few areas of the law that are especially tricky for companies with the dispersed workforces, the first of which are non-compete agreements. And even if your company doesn't use non-compete agreements, this discussion really is still relevant to you because the issues I'm going to highlight here really play out in a lot of different areas of employment law. So as you probably know, a non-compete agreement is an agreement in which an employee promises not to compete with the employer for a certain amount of time after employment ends and in a certain geographic region. This area of the law is notoriously difficult for employers. It's sometimes very hard to enforce non-compete agreements, and it's super state specific. So some states completely ban non-compete agreements for employees. Others impose some sort of limitations like income thresholds. So a company can't use a non-compete with an employee unless the employee earns a certain amount of money. This is an area of the law that's changing super fast. So this year, I think over 20 states are considering new limitations on non-compete agreements. And 10 states this year are considering imposing some sort of income threshold on non-competes. And then states also differ in how long non-competes can last and what the geographic scope of a non-compete can be. So I wanted to look at a recent court case that really demonstrates the importance of making sure that your employment agreements comply with the law of the state where your employee is located. So this is a case, Medtronic v. Walland, which is out of a federal court in New York late last year. So in this case, we have a company that's headquartered in New York. In 2017, the company hired an employee in California. In 2018, the company promoted that employee to CEO, and as part of that promotion, they negotiated a new employment contract, and the employee moved to New York to start his new role as CEO. The contract that they negotiated contained a non-compete agreement and said that New York law governed. And had the employee remained in New York, there wouldn't have been an issue there. But at the start of the pandemic, the employee moved back to California and then resigned 9 months later in December. There was a dispute following the period of employment, and the company ended up filing a lawsuit in federal court in New York to enforce the terms of the non-compete agreement. The result was that the court found that California law governed the employment contract, even though the contract said that New York law was going to govern. And why was that? Well, it was because the employee resided in California at the time of the dispute. And the court also noted that when the contract was negotiated, the employee lived in California as well. So the result there is that the non-compete was unenforceable because under California law, where the employee was located, non-competes with employees are void. So the consequence for the employer here is that it couldn't keep the employee from working from a competitor. And the company probably also had to pay the employee's attorney's fees for the litigation. So in this case, what could the employer have done to avoid the situation? Well, first of all, it probably should have had a relocation policy in place that required their employees to get the company's permission before relocating, in which case it could have denied the relocation request if it felt that it was critical to have an enforceable non-compete agreement with its CEO. So again, that's a judgment call that companies will have to make, right? Whether it's more important to have a non-compete in place with this certain employee, or it's more important to keep the employee happy and allow them to relocate to a different state. But even if the company here hadn't had a relocation policy in place, knowing that the employee was going to relocate to California, it needed to reevaluate its contract under California law and probably execute a new contract that complied with California law. And then even if there wasn't a new contract, it probably should have realized that California law was going to govern the employment relationship and the non-compete with the employee, and it shouldn't have tried to enforce the non-compete. For companies in this situation where you have an employee that's under a valid non-compete, and then the employee relocates to a state where that same non-compete might not be valid, it doesn't leave the company without options to protect its trade secrets and confidential information. While it's not as strong as a non-compete agreement, a really robust non-disclosure agreement can go a long way in protecting a company's trade secrets and confidential information. And typically those are enforceable. Those types of NDAs are enforceable in every state. So what does this mean for Airbnb and other companies with similar remote work policies? Well, you shouldn't be using the same non-compete and probably non-solicitation agreement for that matter for employees in different states. And when an employee does relocate to a new state, you're going to need to reevaluate your employment contract and non-compete agreement under the law of the employee's new state. Okay, let's talk about another area of the law that can be tricky, and that is non-disclosure agreement. So, this is another trend we're seeing. Every year, states are passing laws that limit employers' use of non-disclosure agreements. And historically, companies have used NDAs for a variety of purposes, but really two big ones. And one is to protect company confidential information and trade secrets, but the other is to prohibit employees from disclosing wrongdoing in the workplace. And it's really this latter use of NDAs that states are really beginning to crack down on. And so let's look at a hypothetical that sort of demonstrates the state-by-state issues that companies can run into when it comes to NDAs. So in our hypothetical, we have a Massachusetts employee that is required to sign an NDA that extends to the disclosure of unlawful employment practices, meaning that if the employee witnesses some sort of, let's say, discrimination in the workplace under the agreement, they can't disclose that. Now, I'm going to caveat this hypothetical and say that this isn't the best practice, right? Even in states that would allow an NDA like this, it can be problematic for employers, right? And one issue is that, you probably want to think hard about the type of work culture that you're fostering. If you have an NDA that prohibits employees from disclosing unlawful workplace practices, and how that might affect your ability to attract and retain top talent. But nonetheless, I think this example is a good illustration. So let's go with it. Okay, so the Massachusetts employee relocates to Illinois and doesn't execute a new contract. The employee then decides to publish a tell-all book about what the employee believes is unlawful employment discrimination at that company's workplace. The employer sues to stop the publication of the book under the original NDA's terms. The result here is that the NDA is void under Illinois law where the employee has relocated, because Illinois law does not allow NDAs to extend to disclosures about unlawful workplace practices. So not only is the NDA void, but the company is going to be on the hook for the employee's attorney's fees and costs in the litigation as well. So, what should the employer have done here? Well, at minimum, it should have realized that Illinois law was going to apply here, and it shouldn't have tried to enforce the NDA. It could have executed a new NDA that complied with Illinois law as well. And there are a host of states that have limitations on NDAs, and some of those are California, Maryland, Nevada, New Jersey, New Mexico. So that's similar to non-competes. employers really need to be aware of the states where their employees are located so they can make sure that their NDAs are compliant with that state's law, and so that they can be sure that they will be enforceable. Okay, let's go to the next slide. We're going to talk about how employers can approach offer letters with the remote workforce. So most companies use offer letters to communicate the terms of an employment offer. And historically, there haven't been really legal requirements about what companies have to include in an offer letter, but the offer letter really is an ideal place to make required pre-employment disclosures, which are increasing at the state level. So one trend we're seeing is that states are passing laws to encourage wage transparency. And in this first example, we'll see Connecticut is one of those states. So for Connecticut employees, for Connecticut employees, if the employer fails to disclose the wage range for the position which the applicant is applying for at the time of the offer, that can subject the employer to damages and attorney's fees and costs. And so in addition to these wage transparency laws, we also have states that are requiring a notice and disclosure requirements about non-competes. So for example, if you are going to require a non-compete as a condition of employment, in many states, you have to give the employee notice of that. And each state that has this requirement has a different notice period. And so in this second example, we'll take a look at that notice period in Oregon. So let's say an employer makes an offer to an Oregon employee on April 1st, with employment to begin a week later on April 8th. The employee signs the employment contract with a non-compete provision on April 7th, and then begins work on April 8th. Well, if the employer ever needs to enforce this non-compete, they're going to be out of luck because Oregon law requires employers to provide at least 2 weeks notice that a non-compete is going to be a condition of employment 2 weeks before employment starts. So because here the employer didn't give that required notice, they can't enforce the non-compete. So the takeaway here, I think, is that employers really need to be aware of pre-employment disclosure requirements. And again, those differ state by state. Like with employment contracts, it's probably best not to use the exact same form of offer letter for employees in different states. All right, let's move to the next slide, sorry. So, given these complications, what are companies supposed to do? What are the best practices in managing your employment agreements in a dispersed workforce? So first, I've harped on this a little bit, but you probably shouldn't be using the same form of employment agreements or offer letters for employees in different states, and making sure that your agreements are tailored to the state law where your employee is located is really the best way to be confident that your employment agreement is going to be enforceable should you need to enforce it. You really should be keeping track of where your employees are located and probably implementing some sort of relocation or telecommuting policy that requires employers' consent to relocate, or at minimum requires notice so that you are aware of where your employees are located. And then if you approve relocation, you should strongly consider executing a modified agreement to comply with the law of the state where the employee is located. And don't solely depend on a choice of law provision to exempt you from the state where your employee is located, because as we've seen, courts aren't always going to honor a choice of law provision in an employment contract. So that ends this section on employment agreements. Do we have any questions outstanding that we need to address?
Adrian, really good at answering questions in the chat. So.
Good job, Adrian.
I would just say, from my perspective, I'll just throw in sort of a wrap up, which is, if this seems really overwhelming, it can be, which is, it's why having tools like I have at my disposal, the 650 employee handbook tool, so that I can, account for all these different states that my employees are starting to move to in my handbook really easily, because the updates and all that research on what's happening in each state and, what head count sets off this requirement in that state, it's done and it's updated for me. So I really enjoy that. But there's more to it than that, right? There's a lot of operational decisions you have to make, and a lot of decisions you have to make about culture and about, retention and, what's going on in your industry as you decide whether to have like a sort of all-encompassing policy like Airbnb, where it's like go anywhere, as long as it's not for longer than this period of time. Or if you want to have a more restrictive one where it's like maybe we've pre-approved some states that we know like their laws are similar enough to the ones we're already complying with. The requirements are close enough that we're comfortable with those. So there's variations of what you could do if what Airbnb does sounds like too much. And then I don't know, Adrian, wrap up on your side.
Yeah, I mean, it is complicated. And while Airbnb might have the resources to do this kind of robust, comprehensive policy, not a lot of companies have that same resource and are able to do that. So we think that just being very aware of what the requirements are in each state and tracking those, and that includes what Marie mentioned from the handbook perspective, but also the registration requirements that we covered of what do I need to do to register in each state, and what does that look like, and what paid leave is required in that state, or what 401k plan do I have to provide to certain employees in those states. And so we have a tool that covers that, as well as helping companies trying to navigate what do we do if we want to hire in a new state. What if we just want to think about it? What do we need to know as we kind of make that decision of, are we equipped to hire somebody there? What do we need to be aware of? And our tool covers the pre-decision of what would it look like if we hired somebody there? And then once we decide to, what do we need to do? What are those next steps? Because we know this is a tricky problem for a lot of companies, but it's also the trend. And a lot of companies are going this direction. So to stay competitive, companies really need to think about having that flexibility and allowing that dispersed workforce.
Yeah, that's been very helpful to me and to our finance team as we look at adding new states to the ones that we're already employing people in. And just that kind of flexibility really is so key to companies now. So if you are interested in that, feel free to hop onto our website at 650.com/employment to see that solution. But there's other ways you can do it as well. And this is one of them, right? Continual education, making sure that you're staying on top of the requirements and following the changes in the different state laws and any federal requirements are really key in this area. So with that, we're on the hour now, so we will end this session.